another weekly staff meet or a weekly client call staff meeting. Oh man. I am sorry that I started this week's email to all of you saying no news is good news, because the minute I said that, we have an avalanche of really crazy and difficult legislation to talk about. And this conversation will probably spill over into 2 weeks. I'm glad to have Denise with us today. We're just going to talk about the different laws that have been introduced today. And I have some documents to share and paperwork to discuss with you and give you an idea of what we're up against. I'm hoping that in some respects this may turn to some of it might be good, because there will be some guidelines given. Oh, hold on a second. Let me just. I'm going to mute everybody. There are going to be some guidelines given to at least structure these conversations and these debates and discussions with our tenants about, how much money are we going to be deferring in their rent, and how much of it is forgiven and how much of it is going to be paid back, and all of that. So that's hopefully a framework that we'll get some more information about and a little bit more clarity as time goes on. So we'll start the conversation today. We'll continue it next week. There won't be a conversation this week with Josh about deal of the day or the sale market. He is on vacation this week, but I think we have enough to talk about anyway. The first small topic of conversation was a piece of legislation that came out of nowhere that John brought to my attention this morning about a payroll tax credit that's being offered. The federal government is saying that companies can opt to not collect the 6% Social Security out of their employees' paychecks for 4 months for the end of the year. And then they will have to pay 12% in January through April, which, if you were here a little earlier on the call, there's a couple of unintended consequences, of course. First of all, people may not even know what's going on and end up spending all of that money and not realize that it's coming out of their paycheck in January. And secondly, for people who are hourly, I would think that their hours may be curtailed still through the end of the year, but if things hopefully continue to improve, we may be looking at increased hours for a lot of those hourly workers. And as they're paying 12% for their withholding, it may be on a higher number of hours and a higher gross wage. And so they get sort of double whammied with paying double the Social Security and paying it on a higher amount of gross income. So, I confirmed with our payroll company today that it is an opt-in program. I don't know why anybody would do it, but I will hold my thoughts on the thinking behind it as this relates to a federal or a presidential election year. But we also have a CDC recommendation and Trump signing on for a nationwide eviction ban. And with that, I'm just going to introduce Denise Ledbetter to begin the conversation. And I'm going to have this be more of a dialogue, a one-on-one. But there's a sort of an interplay here between the federal government guideline of no evictions and the state guideline, which is AB 3088, which was introduced at the 11th hour on Monday evening to take effect on Tuesday. So, Denise, let's get started and sort of compare the effect of those two pieces of legislation, as well as how that relates to the local ordinances that we've all been dealing with for the past 6 months.
Okay, so unfortunately, JJ, I am not at all versed at all with the CDC law that has recently been passed or has been discussed about being passed, etc. I must admit that I've been focusing on the effects and all the possible downside of AB 3088, and I was actually out of town on Monday, so I'm just getting up to speed. I can't speak on the CDC issue other than the fact that the federal government will, of course, take precedence over any state or local government if there is a conflict. And then the fight is on right there about that. But I have not even seen the legislation. I've
Okay.
only heard about the law, so I
Yep.
apologize, but I'm
Well,
not
that's
ready to
okay. We'll have more to talk about next week in that regard. But as far as AB 3088, let me pull up the flow chart, and we can kind of go through this a little bit, and then talk about how this relates to San Francisco, because as is normally the case, we end up with a much more stringent regulation and in San Francisco. And hold on one second, resume share. There it is. Okay, can everybody see the flow chart here?
Yes.
Okay, perfect. So this, along with a raft of new forms, was available first thing Tuesday morning, and I was kind of surprised and impressed to see that the California Apartment Association had these forms ready to go Tuesday morning, 10 different forms, and a bunch of different recommendations of how to use them and put them into effect. So let's talk a little bit about the effect of what happens to any past due balances that we've had from March to August.
Well, depending upon the circumstances of what the parties did, if something was forgiven, my suspicion is that the rent would be forgiven.
Right.
If there was no forgiveness and there was deferment, then what this is basically saying is effective September 1st with a 15-day notice, you can go through the whole sort of flow chart of you provide a notice to the tenant of any rents due from March of 2020 through, for example, September of 2020. And also you will need to provide a letter to the tenant confirming whether or not it's COVID related. The tenant will need to identify if it was or not and provide supporting documentation. And then you either agree or not agree. And then the soonest you can proceed to evict, should they not make a deal on how they are going to start the repayment of rent, then you can evict. Under no circumstances can the tenant presumably pay less than 25%. Now there's a rent each month. Now it is, at this point, it's impossible to really appreciate the significance of this because there's so many different factors that come into play that it really should be taken on a case-by-case basis. And just for your own edification, San Francisco Apartment Association people are getting together, including myself and other attorneys, to figure out how this will actually go down in San Francisco County. They're also, for example, they're also opening up the small claims courts. So if you want to proceed to not evict and breach of contract, open goes the small claims court. There's going to be a ton of litigation in there. Right. So there's so many things that need to be considered for the long haul, a short haul, who the tenant is. Do you want the tenant? Do you want to keep the tenant? Do you want the tenant out? Are there roommates moving in and out, and et cetera? There's just, it's a mess.
One of the pertinent facts of this, though, is that the past due rent from March to August becomes consumer debt, and they've removed the cap on small claims court cases, which was something that seemed like it was a logical step to me when I thought about this. If they're going to say that you can't evict, they shouldn't make it so that you can't collect. And the old limit, I think, was $7,500 maximum value of a small claims case. And so now they've said there's no limit to small claims cases. I think as it relates specifically to COVID-related non-payment of rent during that March to August period of time. But it is it's a challenge to get through small claims court and then to get a judgment and then to collect on that judgment. I don't think I haven't been to small claims court very many times. And I've never had a judgment and had to collect on it, but doing so is sort of leading down a rabbit hole that you may never find the bottom of it.
Well, actually, so small claims court jurisdiction currently is $10,000, but you are correct, JJ, in that presumably there's no limit for the collection of rent for COVID-related non-payment. However, you may not proceed to small claims until after March of next year.
March of next year. So yeah.
You can continue the process. So for every month, you would give a 15-day notice of the rent due. And So again, it's essentially work it out with your tenant, whatever you can work out with your tenant. It's further confirmation that everything that we've been trying to do, short of eviction, should continue to be done. Now there's just a particular process in place regarding how that is to work in the days and the 15 days and the dates, etc. There's also the catch-all that no further moratoriums, local moratoriums can be put into effect until I believe it's January 1st of next year. I double check that there's many dates in this litigation, in this legislation, so I'd have to check that, but I'm pretty sure that no more changes to local moratoriums can be made.
So let's talk a little bit about the income qualification of this. There's an income qualification requirement here that a tenant they have to self-declare that they make less than 130% of area median income or something. What is that detail? I'm trying to find this on the flow chart, and I'm kind of wondering where we're at with it. But what is if tenant returns the declaration and documentation if they're a high income tenant. So if they're a high income tenant, they have to return documentation to prove that they have lost their income and that they need the deferral of rent. Is that what that means?
That's my understanding.
Yeah.
And then median household income, obviously, that's going to be different in San Francisco than it would be in Lake County. And so one of the things that we would need to do is, I'm pretty sure it's the Mayor's Office of Housing that provides those statistics. But again, who does? So we have to look at that again.
Well, the area median income for Alameda County is $108,485, and in San Francisco, it's $130,000. I think I saw. There it is, $130,000. So, any tenant that makes less than $130,000 in San Francisco is going to have to require documentation. But so a tenant can self-declare that they are not a high-income tenant and not have to provide any paperwork. Is that what that seems like?
Yeah, it does. But what if the tenant has changed jobs? There's all kinds of things that can happen. And what if you have 3 tenants and they make $300,000 a year?
Right. Is it per individual resident in a multi-roommate property? Is it? It seems like it leaves the door open to enter into a specific agreement with an individual tenant. If you have one tenant in a roommate situation who has lost their job and the other roommates want to keep paying, instead of having to take action against all 3 people, you can make a side deal with the one person who's lost their job and needs to stop paying rent for a little while or pay a reduced rent, pay 25% of their rent. But it's complicated.
It's very complicated. And one of the things that we face in San Francisco County, for example, is who defines a household.
Right.
And one of the things, as we all know, if a tenant decides to get a new roommate and the new roommate really doesn't qualify and the landlord says, I really don't want the new roommate, well, the tenant on the lease can just simply say, well, that person is a member of my household and I'm going to take full responsibility monetarily for that person. And then you have to approve that person. So is that going to be the same way here? Are people going to say, oh, they're a member of my household and then so automatically get the rent deferment? So we don't know. And we won't know until the rubber hits the road. And we're not ready for it yet. So we just need to be cognizant of all the possible defenses when we create documentation. Right.
And part of what we've been sort of facing in this process has been tenants making, I don't know if it's a logical error or if it's a conflation of 2 aspects of what's going on right now, but the pandemic caused people to lose their income and lose their jobs. The loss of jobs, while at the beginning of this, if these calls when we were talking in March and April were, really stressful, thinking, how many people are not going to pay the rent in April? And it was interesting the first few months of this, wondering how bad it would get. But when I think about the number of people where we have right now between 30 and 35 people who have some unpaid balance. The bigger issue has been all the people who have just fled and left us with vacant units, which, they left given their 30-day notice, and, a few people broke leases, but mostly it's the vacancies, and that's absolutely sunk the market. And now we've got all these vacancies. And then people are making a logical leap to say, well, the market is down. I don't want to leave. I'm going to ask for a deferral, and I'm going to claim that my rent is too high because the market is down. And the two things don't have anything to do with each other. And so we're finding ourselves having conversations with tenants to say, hey, if you're asking for a COVID deferral, let's talk about how much of a deferral you need. And sometimes people are coming to us and saying, well, I've lost a portion of my income. I used to make, my base salary is X, and then I had extra, side job or this, that, or the other thing that added another 10 or 20% to that. And then they say, and the market's gone down, so can I have a 30% reduction in my rent? Well, okay, well, let's back up a second. If you're talking about having lost income and you want to talk about reducing your rent for a period of time until your income recovers, and then we can talk about what to do with the deferred rent later. Let's talk about how much your rent, your income has been reduced, and then reduce your rent accordingly. But if you want to talk about, gee, let's sign another deal and we'll talk about, reducing your rent, we'll talk about that separately. But that's a situation where you kind of have to be ready. If we don't make an agreement on that, you have to be leaving. I mean, eventually, or we're just going to have to agree to disagree, and you're going to keep paying your rent. So, what do you recommend when people come to us with that sort of conflation of two effects of this big cause?
Well, I appreciate that you think it's a different conversation, but the reality is that it does affect you practically.
Right.
And so I think that it's really a business decision on the part of the owner to determine what that party and that matter is going to resolve itself for, whether it's going to be a rent reduction, and it's just a business decision. Right. I think that you can definitely say, sorry, that's a completely separate issue, and it has nothing to do with COVID directly for you and your income.
Right.
That's my problem, tenant. If you don't like living here, that's one thing, but the problem with the market is my problem. Your rent is what it is. But it does obviously come into play because you're going to want to keep a happy tenant, and you want to keep them going past the month to month or past the term, and see where things happen. But you're right, it's completely legally a separate process.
Right. And I think it speaks to the my initial thought about this process was that we didn't have to feel any pressure to make a decision about what would happen for people who had to defer rent. If they couldn't pay the rent, they weren't going to pay the rent. And there was nothing we could do about that. And we don't need to rush to make a decision about, are we going to forgive this, or are we deferring it, and how are we going to collect it? Right now, we don't know how we're going to collect it. We still don't know. And this is giving us a timeline for when we might be able to start talking about collection. Perhaps we might be able, I guess under this new rule, any of those past debts, we can't use a stipulation for entry of judgment as a tool to motivate people to pay on time and as they agreed. And I guess if we work out a payment plan, we might, I guess we have to get a judgment. Can you do a similar sort of a thing for a money judgment in small claims court?
I mean, see what you're doing?
Yeah.
You're thinking and you're like, wow, what if this, that's exactly where we're going to be.
That's where the lawyers have to go next week.
Yeah, I don't necessarily disagree that you can't enter into a stipulation. You just need to follow the rules.
Right.
And so if you've given the notice, the 15-day notice, and et cetera, and you've processed, and then you can proceed to do a breach of contract, and the breach of contract could confirm that the right of possession is in exchange for their breach of their agreement. So, but that's not going to happen until next year. Right. None of that can happen until next year, because you do have to have a lawsuit on file in order to effectuate a stipulation. So right. When is this going to happen, with whom and how and what? That's all going to come into play.
Yeah, it's all up in the air. One of the the strategies that I've begun to use with commercial tenants when we are forgiving a significant portion of back rent as a part of collecting, a portion of it. For example, if you have a tenant who's behind by, $12,000, and you're going to agree to forgive half of that rent in exchange for payment of $500 a month for 24 months, I can make it a 24-month agreement at $500 a month. And then if all the payments are made on time for the first 12 months, the rest of it is forgiven. And if the payments aren't made on time, the forgiveness is moot, and the payments continue, and you can maybe take action, consumer action, or, an eviction action for non-payment of those funds. But, it's still taking a tremendous amount of time to sort of work my imagination and try to begin to think about the best ways to approach these things. So it's pretty crazy. Did you want to talk a little bit about perhaps like some sort of scenarios that might be helpful to illustrate, or is it still sort of a little bit too far behind all of this?
Well, I would prefer to receive scenarios to
Okay.
respond to, because I can't just, if you have any particular scenarios that you would like me to address, something that's currently pertinent, that's going to be a lot easier for me.
Sure.
But the reality is that I think that currently we can at least proceed to give 3-day notices, because for a while it was unclear as to whether we could. Well, I shouldn't say 3-day notices. 15-day notices for non-payment of rent. So if the rent is not paid, you give a 15-day notice, and during that period of time, the tenant can identify whether they have COVID-related financial hardship, and then we just proceed through the process in that vein.
Okay.
And you'll probably need to keep track of if there is revolving occupants in a unit that you've made a deal with. Does that potentially change your deal with the tenant or the tenants? How will that be papered, so to speak? So there's so many different facets, like we discussed previously, JJ. Every single deal is going to have to be looked at. You have the framework of the flow chart.
Right.
And you just have to be very cognizant of the factual circumstances in the situation.
Right. John, did we have any particular situations with tenants where you thought they might be, illustrative, and you can sort of give a broad strokes description of something you might, you might be looking to ask Denise about? How would we move forward with something like this?
Well, the first question, I guess, would be the 25% minimum payment requirement. Does that kick in September or October for San Francisco? Because the mayor's order is still in effect until September 30th.
It's my understanding it kicks in for September, but you can't do anything for it. You can't effectuate anything. So I think that if they haven't paid rent, you do the 15-day notice for September, but there's nothing that you can do until after the mayor's order expires. So You're going to give another 15-day notice in October.
In October, right. And it's going to have both months' rent on it, and so then you can move forward. But you have to serve in September and in October to preserve your right to
under state law
in October, right?
Yeah. So about half of our tenants that are deferring rent are not paying anything. So they're going to get these 15-day notices soon, which will probably surprise them, because if we take them at their word, they're still not working. Hairdressers, service people, they're still not working. So whether they can pay 25% is subjective. I mean, I don't know, but we're gonna have some conversations next week about a dozen or so of these tenants that haven't paid anything.
That's right. And then as they leave, because they can't afford, or you make a deal, and then they get new roommates, and then the business is open, and it's just a big.
Yeah. So one other scenario that's happening is at the beginning of the pandemic, we had a few tenants who lost roommates and could not replace them for obvious COVID safety issues. That, you know, wasn't safe for somebody to move into their apartment, so they couldn't find any roommates. Now the situation is their rent is too high, so they can't replace roommates that have left because nobody will move in at that price. So these tenants are, I think I have 2 or 3, they're deferring a portion of rent because they say this is a financial impact of COVID. COVID has caused the market to decline and I can't find a roommate. It's because of COVID. So this goes back to the argument you had earlier about is it economic or financial? And it's so the lines are blurry here with these tenants that don't actually qualify.
Right, they still have jobs.
Yeah, they still have jobs. Yeah.
That's a tough one, John. That hits right on the head of what we're going to face, because I think respectfully, presumably we have tests, right? So if somebody comes to you and says, I'd like to rent this property, I'd like to be your roommate, do they not know anybody? And if they don't know anybody, can they have people be tested? And then right before they move in, they get tested again? And what does that stop anybody from being infected by COVID even after they're in? Even the roommates who are saying we don't want anybody new in. So it's just, I don't know if it's necessarily legitimate or not, but that's not for me to state. It's have everybody get tested every day. It's just silly.
Well, that would be the ideal for the entire country, is that we could have enough testing, but we dismantled our testing regime and didn't fund the labs. So here we are.
And what about the false positives and the false negatives? So
right.
Who do you really know is infected?
Right. But the other question, Bert, go ahead.
I can talk a little bit about the CDC if you want.
Okay. Yeah.
The CDC, unlike the local, has a limit on $99,000 salary as their distinguishing. So a couple would have presumably double that or would have double that. They don't talk about multiple tenants or anything like that, but that's kind of the guideline. And that's being declared under the CDC authorization because it's a public health concern that these people will be put on the streets. They won't have a place to go, and the virus will. So that's the sole reason for it. It has nothing to do with any kind of economics at all. It's an emergency proclamation, and I guess you would call it the dump it on your shift, Biden, as it runs out in January. So yeah, you take care of it, how to fix it. But that's and it is thrown together. There is a move by Congress to try and pay the renters' obligations to cover the health crisis going on. And I don't say it directly, but you might talk to Mrs. Pelosi once she gets out of the hairdresser about.
She said that was a setup, but yeah.
Yeah, right. Anyway, but it isn't terribly complex. It is probably not very well thought through either. But it is not something that varies by location or any other standard. It's just $99,000 or below is what it runs on. That's a help. And presumably, if it overrides everything else, all this argument with us is moot.
Yeah, well, we'll see. It'll be very interesting to see what the update is next week after the legal minds gather and have a conversation about that. I'm sure it's going to be fascinating. Yeah, it's complicated, but I also, just to put it in greater perspective, I also will say that we have in our portfolio, the bigger problem is what's happening in the rental market, and the fact that we're having an issue just getting units rented because people aren't coming to San Francisco. And we're committed to working with our 30 to 35 people who have a past due balance, and the half of those people, 15 to 18 people who have who are paying zero rent. About the other half has resumed paying rent in the last couple of months in some way, shape, or form. So, that's good news. And the other issue is certainty of when businesses can reopen, because I've got deals with commercial tenants, retail tenants who are looking at well, when do I get to reopen? And if I reopen, does my rent go back to full? Because I have some, restaurants and bars where we have deals that say, when you're reauthorized to reopen in full, you're going to resume paying full rent. They've got some of them on half rent. And the issue there is, people may not be they probably won't be making their decision about when they're going to be ready to go out and party again and be at restaurants and bars with crowds of people based on when the local authorities say it's okay for those bars to open. It's going to take a while for people to be really comfortable and confident enough to go back there. So even if they're authorized to reopen, they're not going to have a full house. It's still going to be a long time before we end up with, revenues back to where they used to be. Yeah. So anyway, does anybody else have questions or comments? I mean, you want to seed the conversation for next week with other questions that we might be able to answer next time?
Yeah. Today, the governor announced a new website, in case you're interested.
Okay.
It's called housingiskey.com.
Okay.
I'm going to have, it looks like they just threw it together very quickly. Right. You might want to take a look and see it. It has landlord stuff, tenant stuff,
right,
rights, and things.
Yeah,
like that.
I looked at that website, and it's put together by the Department of Real Estate. So that's a good source for it. For any of you who are, you should all be California Apartment Association members. If you're local San Francisco Apartment Association members, you are already members of the state association. They've got the comprehensive information there, and it's their regular bulletins, both the local and the state bulletins are a valuable source of information, as well as their magazine. So take a look at those as well. Those are also resources. But I think the other bottom line here is work it out yourself. Work it out yourself. Work it out yourself. Everybody, you look at these things and you go, oh, okay, all right, I'll forgive some rent. Let's just make this thing go away. Let's do what we can to keep you there, or to avoid getting into court, because that's going to be a nightmare. It's going to be difficult, and the rulings are going to be erratic because this legislation is erratic. I mean, it's definitely the political sausage making. I don't want to know what went into this one, because it's a really, really bad outcome as far as usability and it's protecting everybody just because it's so scary and weird. So yeah, it'll be interesting to see how we learn about it. All right, well, it was great having you, everybody. Thanks for joining me, and I look forward to seeing you again next week. Have a good rest of your week, and stay healthy and stay safe. It's good seeing you. Bye.
Thank you.
Everybody.
Bye.